Okay, picture this. What happens when the rules for drawing election maps completely change, right in the middle of an election year? It sounds like a hypothetical, but a recent Supreme Court ruling just triggered an unprecedented, honestly almost chaotic, administrative scramble down in Alabama. And the ripple effects of this, they could stretch far beyond a single state. In this explainer, we're diving into the hidden machinery of democracy. Because as you'll see, sometimes the biggest shifts in power don't begin with a change in the votes, they begin with a change in the rules. So let's get into how this situation unfolded, because it happened with breathtaking speed. It really shows exactly what happens behind the scenes when courts, state legislatures, and actual election systems collide under real-world deadlines. I mean, put yourself in the shoes of an election administrator for a second. Absentee voting has already been underway for months. Thousands of ballots have already been cast by early voters and military personnel overseas. And then, bam, a judicial order shifts the very foundation of the districts just days before voters head to the polls. The Supreme Court stepped in, blocked the 2024 map, and suddenly, local officials had to navigate an entirely new reality overnight. To truly understand the sheer logistical pressure here, we have to look at this staggeringly compressed timeline. Anticipating a late-stage judicial intervention, the Alabama legislature passes a contingency measure on May 8th. Literally, 3 days later, on May 11th, the Supreme Court issues its ruling. Now, keep in mind, the regular statewide primary was scheduled for May 19th. That is just 8 days away. This forced a monumental pivot, pushing the special congressional primary for the affected districts all the way back to August 11th. So how did they stop the whole system from completely breaking down? Well, Alabama had to activate what's called a split primary mechanism. It's a procedural twist that honestly feels almost unbelievable. First, the May 19th primary proceeded normally for all the statewide races. But for the congressional races in the 4 affected districts, any ballots that had already been cast were legally voided. They were just erased. Voters in those specific districts had to cast entirely new ballots in August. And to make this whole thing work, officials opened a rapid candidate qualifying window that lasted just 48 hours. It's basically the political equivalent of trying to build the airplane while you're already in freefall. Now, behind this wild administrative feat is a very profound demographic reality. By reverting to the reinstated 2023 legislative map, District 2 underwent a massive transformation. Under the 2024 court-ordered map, District 2 had a Black voting age population of roughly 48.7% because it combined the southern Black Belt with Mobile. But the newly reinstated 2023 map, that drops the demographic down to under 40%. It does this by bringing in the Republican-leaning Wiregrass region and splitting up Mobile. A demographic shift of that magnitude scrambles reality for the candidates on a dime. Sitting representatives and hopefuls suddenly woke up in completely different political environments. Representative Shomari Figures, for example, was effectively drawn entirely out of the 2nd District and placed into the 1st. State Representative Red Marquez immediately had to pivot his entire campaign to the newly reconfigured 2nd District. We're talking about campaigns that took months, sometimes years, to build, being rewritten in a matter of hours. Meanwhile, former Representative Jerry Carl remained in his 1st District race, but found himself navigating a totally altered playing field. But here's the thing. The catalyst driving all this local chaos in Alabama is actually a much deeper, structural shift in how federal courts evaluate voting rights nationwide. The legal framework governing minority representation traces all the way back to the Voting Rights Act of 1965. And for decades, federal courts have slowly refined how that statute is applied. But right now, the legal environment itself is transforming, moving away from the standards that have governed redistricting for an entire generation. What we are observing is a monumental transition from an effects-based standard to an intent-based standard. For 40 years, following the precedent set in Thornburg v. Glingles, courts primarily looked at the effects of a map. They were basically asking, did this map accidentally dilute minority voting strength? But a landmark April 2026 ruling fundamentally altered that framework. The Supreme Court established a strict, intent-based standard. Now the courts aren't just looking at the outcome anymore. They're asking, was there intentional discrimination on purpose? This rigorous new intent-based standard makes it significantly harder to challenge an electoral map. It requires plaintiffs to prove specific, present-day, intentional discrimination by state actors. And on top of that, they have to completely untangle race from partisan preference, meaning they must prove that an alternative race-blind map could fully achieve all non-racial and partisan goals. It is a profoundly higher bar to clear in federal court, and it completely changes the calculus of election law as we know it. And that exact transition is what triggered the Alabama ruling. The Supreme Court vacated the lower court's order that had previously blocked the state's 2023 map. They didn't declare a final winner on the merits. Instead, they essentially hit the reset button. They sent the case back down to the lower courts to be reconsidered entirely under those incredibly tough new standards. And while that extensive legal review takes place, the state-drawn 2023 boundaries are officially locked in for the 2026 midterms. This development really represents a defining clash over institutional authority within our American federalist system. Proponents of the ruling, including Alabama state officials, argue that this is a vital restoration of legislative power over map-making. They contend that the Supreme Court has vindicated the state's authority to draw its own maps, using race-neutral, traditional redistricting principles completely free from federal judicial interference. From their perspective, these decisions properly limit the use of racial targets in electoral design, ensuring that elected representatives, not judges, hold the pen. The dissenting perspective, however, highlights a really deep concern over historical protections and the immense disruption of ongoing elections. Justice Sonia Sotomayor argued strongly that lifting the injunction was inappropriate. She pointed out that the district court had already made an independent constitutional finding of intentional discrimination when evaluating the 2023 map, and she noted that finding remains completely untouched by the new statutory adjustments. Immediately following the ruling, civil rights advocates filed an emergency motion, arguing that these mid-election changes weaken historical protections against vote dilution and cause irreparable harm and confusion for voters who had already cast their ballots. So, what does this all mean for the rest of the country? Well, it means we might be watching a new national blueprint unfold right before our eyes. As these new legal standards take hold, states that are navigating mid-decade redistricting have a brand new framework to test out. The debate over who gets to draw the lines and what rules the courts use to judge them is accelerating nationwide, right as we head into highly contested elections. We can actually already see this ripple effect taking shape in South Carolina. Prompted by the new rulings, the state convened a special legislative session specifically targeting the 6th Congressional District. This is an area currently possessing a 46% Black population under a long-standing compromise. And this move sparked an intense internal debate over strategy. Even within the legislative majority, there are complex discussions happening. If they stretch the boundaries to try and win all 7 congressional seats, do they risk spreading conservative voters too thin? Doing that can actually expose neighboring districts to really competitive challenges in a tight election year. Now compare that aggressive legislative push to the rigid procedural reality over in Virginia. There, a state court struck down a voter-approved redistricting amendment. But when it was appealed, the U.S. Supreme Court declined to intervene. Why? Simply because of strict early voting deadlines and established administrative rules. So Virginia is proceeding with its existing 2021 map. It just goes to show that sometimes the ticking clock of an administrative deadline acts as an absolute brick wall, locking maps in place regardless of the broader legal shifts happening around them. You know, we spend so much time focusing strictly on who wins or loses on election night. But looking across these different states, a much deeper realization emerges about the hidden machinery of our democracy. Legal standards themselves are shaping political reality long before a single vote is ever counted. When the legal burden to challenge a map changes, the map itself changes, the candidate pools shift, and the geographic representation of entire communities is fundamentally altered. As these cases proceed through the courts and institutional checks and balances continue to define American elections, we are left navigating a rapidly evolving framework, which brings us to a massive, unresolved question to close out this explainer. How should courts balance competing goals like state authority, historical protections, and fair representation, especially when the legal standards themselves continue to change?
An investment in knowledge pays the best interest, so why not invest in this channel? Click like and subscribe for more.